So we are clear with the meaning of unpaid seller. If I say the person who is not being paid in full or in part for the goods transfer, for the property transfer, the person is known as unpaid seller. And if the person is unpaid seller, then definitely he must have some rights with him to claim that money from the buyer. So if we talk about the rights of an unpaid seller, these can be divided into two categories: against the goods, against the buyer personally. So against the goods, the unpaid seller has the right of lien, right of stoppage of goods in transit, right of resale, right of withholding the property. But against the buyers personally, the unpaid seller has right to sue for price, right to sue for damages, and right to sue for interest. Let's discuss all these points in detail. Let's first discuss the rights of unpaid seller against the goods. Once the property is still in the possession of the goods but the ownership has been transferred, then the unpaid seller has these rights. The first right is the right of lien. It is under section 47 to 49, defined under Goods of Sales Act 1930. What is the right of lien? Right of lien is to retain the possession of the goods with the seller until the payment for those respective goods is not been made. Means when the seller is in the possession of goods and the payment is not made but the ownership has been transferred to the buyer, the seller, the unpaid seller, has a right of lien or lien of on those goods. But this right can be exercised when the following conditions are being satisfied, or in the following cases: one, where the goods have been sold without any stipulation as to credit, means no credit stipulations were made at the time of the contract. Now the seller is unpaid. Where the seller have been sold on credit but the term of credit has expired. Say there was a time period of credit to pay for the goods for 3 months. Now the 3 months have gone and the payment is still not made. Then this right can be exercised, and when the buyer become insolvent. Now the buyer has become insolvent and is not in a position to pay for the goods to the seller. Now in that case the seller has a right of lien on the goods. And this right of lien, it's important to know that, is linked with the possession of the goods, not with the title. The seller would not give the possession of goods. He would not transfer the goods personally to the buyer, but the title of the goods would remain with the buyer. The unpaid seller can exercise the right only when the goods are in his possession. If the goods are not in his possession, the right of lien cannot be incurred, cannot be exercised. There is a case of Barucha versus Vadhya, with which we can make this point more clear. Mr. A sold certain shares to Mr. B. The relatives' share certificates and transfer forms duly signed were handed over by the seller to the buyer against payment of price by check. The buyer became insolvent. It was held by the Privy Council that the seller had no lien on shares because his lien ceased when he parted with the possession. That means, as this case also clears this point very clearly, that once the unpaid seller has aparted from the goods, aparted from the possession of the property, this right of lien cannot be exercised. Right of lien is indivisible in nature. That means the right of lien would be on the complete portion of goods. It cannot be on it cannot be for the proportionate price. It cannot be for the proportionate goods. Buyer is not entitled to claim the delivery of a portion of goods on payment of a proportionate price. That means if the seller is accepting the proportionate price for the proportionate goods, he cannot exercise this right further. This is also clear with this example. Mr. B sells to Mr. A sells to Mr. B a certain quantity of sugar. It is agreed that 3 months credit shall be given. But Mr. B allows the sugar to remain in Mr. A's warehouse till the expiry of 3 months and then does not pay for them. Mr. A may retain the goods for the price. That means if the whole quantity of the sugar is available with Mr. A, now he is not going to give any amount of the sugar to Mr. B. If this is being allowed, it would violate the right of lien with the unpaid seller. How the right of lien can be terminated? The right of lien is linked with the possession of goods. Once the possession is lost, the right of lien is lost. But the unpaid seller loses his right of lien in the following cases. 1. By delivery to carrier. Delivery to carrier for the purpose of transmission of goods to the buyer. When it is being operated, that means this unpaid seller has lost his right of lien. It is clear from the example. The goods sold were delivered to buyers, shipping agents who had put them on board a ship, but the goods were returned to the seller for repacking. While they were still with the seller on this mission, the buyer became insolvent, and the seller, being unpaid, claimed to retain the goods in the exercise of his lien. It was held that, having lost his lien by delivering to the shipping agent, his refusal to deliver was wrongful. That means once when he has delivered the goods to the carrier for the purpose of transmission to the buyer, that means he has lost his right of lien on the goods. Second is by delivery to buyer. That means once the unpaid seller has delivered the goods to the buyer, that means he has lost his lien of goods. Seller's right is not defeated where the buyer has obtained the possession without the consent of the seller. That means if by using some wrongful act, by using some wrongful means, if the buyer has taken the delivery of the goods, taken the possession of the goods, that means the seller's right is not defeated. Even the goods are in the possession of the buyer, the seller can still exercise his right of lien because the goods are being transferred to the buyer without the consent of the seller. The buyer has done some wrongful act and has adopted the goods. Third is by waiver. If the seller by using his authority has waived his right, that means he don't want to possess the good with him for not paying for those goods, the right of lien is terminated. A waiver is expressed when it is mentioned in the contract. That means when the contract was made, if it is being mentioned in the contract that in case of non-payment for goods, the goods cannot be held, the right of lien cannot be exercised, then it is a express waiver, and in this case the right of lien is terminated. A waiver is implied where the seller sells the goods on credit or grants of fresh terms of credit. Let's suppose there was the term of credit in the contract when the contract of sale was made, and on the day of the payment, now the seller has given 2 months more credit, let's suppose. So that means when the seller has given a fresh credit on the goods, on the terms of the credit, fresh terms of credits are being given, that means he has lost his right of lien on the goods. By tender of price means when the buyer tenders price for goods, the seller no more remains an unpaid seller, and when the seller is not an unpaid seller, he cannot exercise his right of lien. The second right of unpaid seller is the right of stoppage in transit, which is covered under section 50 to 52. Right of stoppage in transit means to stop the goods in transit. Means once the goods have been shipped by the seller to the buyer, now the unpaid seller wants to stop those goods in transit. That means he is using his right of stoppage in transit. That means the right can be exercised only under the following circumstances. One, the seller must be an unpaid seller. The seller must have parted with the goods, but still the buyer have not acquired it. means goods are still in transit. These are apart from seller and apart from buyer too. The buyer must be insolvent, means the buyer should not be in a condition to pay for the goods. Only then the unpaid seller can use this right. This is clear from the case of Bethel versus Clark. Mr. B, who had bought goods from Messrs. Clark and Company of Glasgow, instructed the sellers to sell the goods by a certain name the ship to Melbourne. Goods were first railed to London and then shipped to Melbourne, a maid's name receipt being sent to buyers. On the way, Mr. B becoming insolvent, the seller gave notice to the railway company to stop delivery to buyers, but it was too late. Then they gave fresh notice to the ship owners claiming back the goods before the ship arrived at Melbourne. On arrival there, the receiver in bankruptcy of Mr. B demanded the bills of lading from the master, held the goods have been effectively stopped in transit and trustee could not claim them. That means once the goods are out of the possession of the seller and the buyer has not received the good till date, that means if in that between time, if seller exercise his this right of stoppage of goods in transit, this is a valid right with him. What we mean by duration of transit? Goods are in transit from the time when they are delivered to a carrier for the purpose of transmission to the buyer until the buyer takes the delivery. The period in between is known as duration of transit. The carrier may hold the goods for as a seller's agent in case seller has exercised his right of stoppage in transit, as buyer's agent when seller cannot exercise his right of stoppage in transit, and also as an independent contractor. The unpaid seller may exercise the right of stoppage in transit. How? By actually taking possession of the goods. That means he can goods back into his own custody, by giving notice of his claim to the carrier in whose possession the goods are at present. That means the carrier who is taking the goods to the buyer on behalf of the seller, the unpaid seller can give the notice of his claim to the carrier that the goods should be stopped in transit, means it should not be delivered to the buyer. So we have read with the right of lien and right of stoppage in transit. But what is the difference between these two? Let's see. First is possession of goods. What is the possession of goods? The right of lien can be exercised only when the goods are in the possession of unpaid seller. But the right of stoppage in transit can be exercised when the goods are not in the possession of unpaid seller. These both are different. Right of lien when goods are in the possession of seller, and right of stoppage when goods are not in the possession of the unpaid seller. Insolvency of the buyer. The right of lien can be exercised even when the buyer has not become insolvent. Means buyer is not insolvent but he is not paying, even then the right of lien can be exercised. But right of stoppage in transit can only be exercised when the buyer has been declared as an insolvent. Termination of right. Right of lien can be terminated as soon as the unpaid seller loses the possession of the goods. Means the possession of the goods is lost, right of lien is also lost. Right of stoppage in transit is terminated as soon as the carrier of goods loses the possession and delivered them to the buyer. Means once the goods are being given to the carrier to give the goods to the buyer, and once he deliver the goods, the possession is lost, the right of stoppage in transit is lost. Process of right. The essence of right of lien is to retain the possession of the goods, and in case of stoppage in transit, it is to regain the possession of goods. Here it is to retain, and in case of stoppage in transit, it is to regain the possession of the goods. What is the essential element? Essential element in case of right of lien is, it is a possession is the test of a right of a lien, and that is if the possession is lost, right is lost. And in case of stoppage in transit, non-delivery of goods by the carrier to buyer is the test of right of stoppage in transit. Means if the carrier has not transferred the goods to the buyer, this right can be exercised. Third right of unpaid seller. First we have discussed with the right of lien. Second we have discussed with right of stoppage in transit. Third is right of resale. Under section 54 of Sales of Goods Act 1930, the right may be exercised in following circumstances. One, when the goods are of a perishable nature. Perishable nature goods cannot be retained for so long, so to claim the price, the unpaid seller has the right to resell them. Where the seller has exercised his right of stoppage in transit, he can give the notice to buyer of his intention to resell. Means once the unpaid seller has exercised his right of stoppage in transit, now he may intimate to the buyer that if the buyer is not going to pay in some specified period, he will sell the goods to the other customer. In case the buyer makes default, buyer is not going to pay any kind of money for the goods sold to him, then the unpaid seller has the right to resale. And when the seller exercises this right, the buyer who acquires goods title theirs too as against the original buyer. The fourth right of an unpaid seller is a right of withholding delivery. That means this right is similar and coextensive with the right of lien and stoppage in transit. In this, the unpaid seller can withhold the delivery of the goods to the buyer, and this right can be exercised even if the sale was on credit or that the goods were specific or unascertained goods. That means in case of an unpaid seller has the right of lien, right of stoppage the goods in transit, right of resale and right of withholding the delivery. Now we will discuss the rights of unpaid seller against the buyer personally. Till now we have read the rights against the goods. Now we are reading the rights of unpaid seller against the buyer personally. Number 1, suit for price under section 55. If the property has passed to the buyer and goods are in his possession, then the unpaid seller has only remedy for the price, because he has lost the possession of the goods. Now he cannot retain the goods, he cannot stoppage the goods in transit, he cannot resell the goods. But what he can do, he can only suit for the price of goods. Here the if the price is payable on a certain day, irrespective of the delivery, the seller may institute a recovery for a suit for recovery of the same too. Second remedy is suit for damages of non-acceptance under section 56. If the buyer wrongfully neglects or willfully refuses to accept the goods or to pay for the goods, then the seller may exercise his right to claim to file a suit for damages for non-acceptance of goods. Third is suit for interest under section 61, where the buyer wrongfully refuses to accept the goods and is not paying for them, then the court may award interest on the price of the goods. That is the right of the unpaid seller. Means if the buyer has not paid yet and is delaying the payment, he can file the suit in the court for the interest on the original payment due, and this interest would be from the date of tender of goods to from the date when the price is payable. And in case the goods were sold on the credit, the interest will run from the expiry of the credit period. Let's say the goods were sold on 1st January, the credit period was on 1st March, and after 1st March till when the buyer would not pay the payment, he has to pay the interest on the original payment. And seller is entitled for interest when he is in a position to recover the price. Means if in any suit it is being found that unpaid seller can't claim the price from the buyer, then he is also not able to get for the interest on the original amount. And if he can sue for damages for breach of contract, he is not entitled to interest. It's very interesting to know that once he has filed a suit for breach of the contract, in that case he is not entitled for interest. He can claim interest only in the case when he is filed a suit to recover the price of goods from the